Senior Advocate V. Sridharan sir. Sir is going to address us all on the topic. Topic: Benami law, fundamental concepts and the implications under the Income Tax Act. I would now request Advocate Harish Shah sir, Chairman Registration Committee, to escort Senior Advocate V. Sridharan sir onto the dais along with the other dignitaries, Madhusudan Patel, Advocate Kandab Gajjar, Advocate Umesh Majmudar, Advocate Nitin Vadodaria, and C.A. Siddharth Thakkar. To the dais, we welcome CA Mr. Ravi Savana too, along with the sir on the dais. Have you amongst us today. Let me now take this opportunity to brief you all about Senior Advocate V. Sridharan sir. Sir is a designated Senior Advocate, a qualified CA and a cost accountant. He is a founding partner of the law firm Lakshmi Kumaran and Sridharan, a leading firm of advocates in indirect taxes, anti-dumping and WTO laws, IPR laws. Sir has been practicing since 1983 and is a seasoned lawyer possessing vast experience. Mr. Sridharan sir has delivered many lectures on direct tax laws and indirect tax laws at various prestigious and professional institutes. I now request Advocate Harish Shah sir to present a book to Senior Advocate V. Sridharan sir. Let us all give sir a big round of applause. I would now request to present sir with a memento. Umesh bhai. Umesh bhai. Ji sir. Sir, please present sir with a memento. Let me take the privilege in welcoming V. Sridharan sir to grace the podium. Sir, please, the stage is all yours. Welcome sir with a huge round of applause, ladies and gentlemen. Sneha Mehrotra.
He should be a counsel in the court. Excellent. Very. Okay. I am with my colleague Ravi Savana. Of course, Jigar refuses to come to the stage. Okay. The topic for discussion today is Benami law and Benami dar, etc.
Yes.
Okay. So in today's session, I am the Benami dar and Ravi is the real owner. That's what the essence of the topic is. Somebody who shows his name on paper, okay, is the Benamidar, and the person who really knows the thing is the real owner. That's what Benamidar means. So I was just checking with Ravi, what's this? Because sometimes not knowing Hindi is a big advantage. So I don't know the meaning of the word Benami in Hindi. So he was saying,
Benami.
without name.
Yeah.
There was, I'm told, a story about Ford. Okay. Some customer went to Ford factory and purchased a new car and says, I'll buy directly from the factory. Famous story, everyone must knowing it. So, and the customer drove the car from the assembly line to the gate and the car stopped. Brand new car stopped. So the customer was furious. He says, Ford का नाम तो सुना है, तो आधा किलोमीटर में चला बंद हो गया. I will talk to the MD and complain to him. He spoke to the MD. MD said, cannot happen, just wait, let me check. He checked up and told him, sir, we are not yet fitted the engine. It has ran the half a kilometer on Ford's reputation, it said. So we say, what is there in a name? A rose is rose, in whatever name it is called. But that's not the Benami law. Okay. Benami law is different. What is it? So the subject of discussion today, of course, is little technical and little boring, but very draconian. Where you are practicing as a lawyer or chartered accountant, if you have some little bit of money, you must know Benami law for your own safety, because what you think is a perfectly legitimate transaction can unknowingly land us up in this Benami trap. My father-in-law, who was an IA&AS man, he called me up after seeing that. Sridharan, I purchased property in my wife's name, that also becomes Benami. And I am told in Benami you can be sent to 7 years jail, property will be taken away, and penalty will be put. 3 things will happen. Your property will go, it will be confiscated, penalty will be put, and criminal prosecution, sent to jail. Nothing is more draconian than this. Okay. Then I said, Papa, it is not so. Fortunately, if you purchase in a close relative's name, I am not using the word close relative's name, from disclosed sources, the act excludes you. Otherwise, the way it is worded, you buy in a son's name, father's name, wife's name, could all be in trouble. And trouble is not only the officer assessing you 30% income tax. Property confiscated, then prosecution and penalty for that. So therefore, it's necessary we know Benami law, fundamentals of it, because the law is so widely worded that anybody can be trapped. The purpose of the discussion today will be twofold. Of course, our main focus will be the 2016 Act. 88 Act as amended in 2016. But those who are close to me always trouble them more, always. I'll give you a little bit of background of civil law on what Benami is, and also a little bit of background on trust law, because this is closely linked with this. Once we understand that background, rest reading the section is very easy. That's what our objective is. Okay, sir? Shall we start now? Okay. This is what we said. We'll deal with Benami in civil law a bit. Ravi, whenever I'm making a mistake, please correct. Okay, don't hesitate. Okay. That's your sole job. Okay. Some elementary principle of trust law. Okay. Then the Benami law as it evolved from time to time in India, what happened in 1980, 72, 88, etc. Some historical background, so that when you have some problem, if you go back to the Law Commission report, etc., things become very clear to us. And lastly, current law and issues. Once upon a time, sir, when we started our career, 90% of the cases would be assessment, reassessment notice barred beyond 4 years, 6 years, over. But now it's all very complex. So it is necessary that we equip ourselves somewhat technically. The open and shut cases are not there nowadays. So very close fight. Okay, right. So this part is important to understand before we proceed to the A is purchasing property from B. A is the purchaser, B is the seller. A pays consideration, but gets it registered in the name of X. Let us say is cook or a gardener or servant. Let us hypothetically. Okay. The sale deed, we all know immovable property has to be a registered document. It is registered. It is registered in the name of X. Okay. And from the property, rental income comes. Okay. So the facts are, A has purchased property from B, A has paid money for purchase of the property from B, but gets the property registered in name of X. Okay. Registered document is in X name. And that property fetches rental income. Who should be liable for income tax on this, sir? Rental income? Yes, yeah, who, X. Who said A, sir? Sahi bola, sir, daro mat. A is the correct answer, X is the wrong answer. Somebody said A. Correct. X is incorrect. So, I will also modify the question. Who is the true owner of the property, sir? X, sir. कागज तो उसके नाम पर है. Registered document. So, this is the mistake. I'm looking knowledgeable now, but before studying this, I also said the same thing. Okay. Yes. Why I am emphasizing it is, transacting immovable property can be effected only by a registered document. Registered in the name of X. And section 92 of Evidence Act will say, once a document is by writing and registered, no evidence to the contrary can be adduced. That also is there. You cannot say, sir, registration document है, उस पे गलत लिखा गया, actual position is, that's not possible. Despite that, A alone is the owner of the property. He has paid the consideration. X is not the owner of the property. Income tax will be assessed in the hands of A, not in the hands of X. Okay. This is very important. Why? Our Privy Council, Federal Court, pre-1950 said, we have some concept of trust law in UK. This Benami is similar to that, not same. There is nothing unethical about it. It can become unethical in some situations, and since once they say, Kali Yuga mein adharma overcomes dharma, then, so when ethical part of Benami has become secondary, the legislation becomes careful and enacted this law with a vengeance. So otherwise there is nothing wrong in holding property Benami. Legitimate reasons. What is that? Kushal Chand Bajaj, no? The judgment. This is famous judgment of the Supreme Court, much before this, income tax case only. HEF, property is purchased with HEF funds. So whether it is taxable in the hands of the individual member or HEF. Court held, whosoever has provided the consideration, he is the true owner, income will be axed at his hand. So please don't go by formal documents. Please don't say, sir, what is this? We all know C8 is a BM Karwar. Legal form of a transaction cannot be ignored. And you cannot tax based on substance of the transaction. That's a different concept. In tax matters, you always go by the legal form of the transaction and not by the substance of the transaction. For example, A sells to B with an agreement to repurchase after 5 years. A sells to B with an agreement to reconveyance after 5 years. You don't call it a lease for 5 years. Effectively, lease for 5 years can be achieved by lease of 5 years or sale with an agreement to repurchase. There, legal form of the transaction is sale and repurchase. That cannot be equated to lease. That is not conflicting with what I said. Law looks at the real state of affairs and not at apparent state of affairs. Therefore, in the example we took, income tax will payable by A, he will be asked. Normally, that will be the position. That's all. Sir, he has paid cash. In Gujarat, cash is the king. Is it not so? Very good question. And the answer I gave is not a mischievous answer. I want to say You have to prove what you have asked is a very good question. I am thankful to you. If proved that A is paid the consideration, whatever Bhashan we discussed will apply. How to prove is a different question. So what you are asking is, okay, if proved that A is paid the consideration, X is not paid the consideration, X is not capable of paying the consideration, then what we discussed. How do you prove? That's the point you are raising. If you record in the books of A as his asset, then it's easy. Though in paper it is shown as X. It will never happen. In Benami transaction, there will be no record of anything. But you have to independently prove. So don't mix up the factual way of proving A has paid the consideration with what happens if he proves. What we discussed is if he proves that A has paid the consideration, this is the consequence. Okay. Good question.
So just a minute. I would request everybody to please hold on with your questions. We will definitely be having a round in the end. Thank you so much. Yes. Yes, sir, please.
In the example of X, I am not saying in a wrong sense, if that person is a gardener or your Mali or something like that, generally you can infer that you won't have the means to purchase the property. Okay. And you don't intend to gift it to him also. Now look at next one. A is buying property in the name of his wife for the benefit of wife, for her to stay and after or times for her to this thing. It is not a Benami transaction, it's not a trust also, because it is the nature of gift of the property to her. That also is possible. There is a close parallel between a gift, a trust and a Benami transaction. In the earlier example, because of your love and affection for the long service which your cook has rendered to you, you want to buy him a flat. That is not Benami. That is not trust. That's a gift. You may gift him cash and he buy. So, the law recognizes all that. You have to prove that on facts. Okay. So, this is what it says. A buying property in the name of the wife for the benefit of the wife is not a Benami transaction, nor is it a trust. Why it is a trust, we will see that. How do you infer it? From the circumstance of the case. Suppose you buy the property in your Mali's name, but you stay in that. That's a clear evidence that you don't intend the driver to enjoy the property. Or rent comes to your bank account. Evidence that you enjoy the property, not the legal owner. That's how it's a question of fact. And the old judgments say, what we call so-called genuine Benami is, you are a member of HUF. You want to start your private, separate business from the HUF. Okay. But you don't want the world to know. In the olden days, if a rich man, then somebody other will conquer and take it away. Okay. So therefore, Benami developed when the state was not strong, it was not able to protect his citizens. Okay. Then he doesn't want the rest of the world to know that he is the owner, therefore buys in wrong names, which is court recognized that is perfectly valid. Next to example, to donate to a temple, that's the case of a gift, that's not a Benami. Then judgment say, 1940 ka judgment, Benami with a malafide intention is government employee, contact rules require to disclose this. मैंने नहीं बोल रहा सर, फेडरल कोर्ट के जजमेंट में लिखा, ये मेरा नहीं है ये. Okay, this word is from federal court judgment. So public servant doesn't want to disclose the immovable property in his name, therefore he buys Benami. And last, which is the major problem, is you want to ward off your creditors. Okay. So I transfer the property in Ravi's name. And Ravi has no debt, only I have debts. So that is the part of Benami which is not legitimate. Okay. And the biggest creditor now is the government, tax department. That is the... Benamis were prevalent widely in India even prior to 1882. What happened in 1882? So nowadays when you travel in the flight, every day you get an announcement. 100 years ago, such freedom fighter was there, some freedom fighter, name भी नहीं सुना हमने. 1882 में क्या हुआ? Indian Trust Act was formed. What I am referring to 1882 is Indian Trust Act. Even prior to enactment of Trust Act, Benami as a legitimate transaction, nothing malafide, nothing illegitimate in it was recognized and blessed by the courts. Okay. let's go to the next one. Sir, I request you to pay attention to this section 81, 82 and 94 of the Indian Trust Act. These sections have been repealed also. Along with the Benami Act, 81, 82 and 94 has been repealed. Okay. But any understanding of Benami law is incomplete without having section 81, 82 and 94 of the Trust Act. And let me tell you, I used to think trust law is very complicated, both bada boot hai. Kuch nahi hai. If you shed your mental fear, then everything is simple. So, main object is only to instill confidence in you that don't, if a client comes, you will be worried that 81 Trust Act nahi malum hai, chartered accountants are, we are chartered accountants, we are familiar with income tax, nothing of it. It's very simple. I had a civil case, sir. So, Mr. Madan, Dinyar Madan was for the other side. And it was a friend's case, so I do not know civil law at all. Okay. So, court asked me, what do you want to say? My lord, let him argue first. He argued. Judge was a brilliant judge. Justice Gupte was a brilliant judge in civil law. Heard Mr. Madan and said no. Then he asked me, what do you want to say? I said, my lords, there is a poster in my office. Let the people think that you are a fool by keeping your mouth shut. Let them not get confounded by your opening your mouth. Karke. Immediately Madan's petition was dismissed with costs also. Okay. Sometimes, as a lawyer you are worried whether it's a subject which is not familiar with it. Nothing of that. That's the reason why I mentioned this, 81, 82 and 94. I'll read the section and then explain it. Where it does not appear that the transferor intended to dispose of beneficial interest, that is, he didn't want to give away the ownership of the property, where the intention of the transferor is not to give away the ownership of the property. What beneficial interest means? Benefit of the property, nothing bigger beyond this. Where the owner of the property did not want to lose his benefits from the property, where the owner of the property transfers or bequeaths it cannot be inferred consistent with the attendant circumstances that he intended to dispose of the beneficial interest therein. The transferee or legatee must hold the property for the benefit of the owner. This is what section 81 says. That is, if the owner purchases a property in the name of the driver, not intending to reward the driver for his past services, then even though legal ownership is the driver, he holds it on trust for the owner. That's what 81 says. What is the meaning of holding in trust? If he misappropriates the property later, he will be in trouble for that. That's the reason. So 81 says, the owner transfers the property and he wants to retain the benefit of the property. That's what circumstances show. Okay. Then the owner is protected. Section 81 says, then the on paper owner holds it in trust for the true owner. If he does something, you will be liable as misappropriation of trust. That's what 81 says. How do you infer the circumstances? The question is whether it is a reward for driver for his long service to you, or you want to buy in his name but for your benefit. It's a question of fact. If you put him in his house, he stays there, that's a different matter. But in that house you only stay or your relatives only stay, you intend to benefit. So that's what 81 is. So 81 therefore gives legal protection to the so-called unfair transaction. A conveys the land to B without consideration. A declares no trust in favor of B. That is, you transfer the property, the trust, and say this property is held in trust for my wife and minor children. There is a transfer to a trust. There is no Benami involved in it. Then the Benamidar holds it for the benefit of the true owner. That's what section 81 says. Now look at 82. 2-3 sections only. Then we can easily run through the current Benami Act. No difficulty on that. Section 82 deals with tri-party. Where a property is transferred to one person for a consideration provided or paid by another person, and appears payer did not intend to pay the consideration the benefit of the transferee. transferee must hold the property for the benefit of the payer. So 81 and 82, hold it for the benefit means if that Benamidar revolts against the master, the law will protect the master by 81 and 82. Section 94 creates an obligation on the holder of the property to hold it for the benefit of the true owner. Section 81, 82 and 94, all of them have been repealed. But the picture is complete only when you know them. The Englishmen, because they were always lords, they wanted to protect the interest of the true owner and therefore enacted section 81, 82, etc. in the Indian Trust Act, which is the position world over. Then two small sections in Transfer of Property Act. Okay. Then the picture is complete. I told you civil law, generally why Benami is, 81, 82 and 94 of the Trust Act. Then section 41 and 53 of the Transfer of Property Act. These are continue to be there. 41 and 53 are there in force. They are not repealed by Benami law. I'll read this and then explain it. Where, with the consent express or implied of the person interested in immovable property, a person is the ostensible owner of such property under the same for the consideration, the transfer shall not be voidable on the ground transferor were not authorized to make it. आपने ड्राइवर का नाम पर खरीद लिया, रजिस्टर भी कर लिया ड्राइवर के नाम पर. Tomorrow, Ravi buys from the driver. Okay. The transaction between the owner and the driver, owner wanted to protect himself and bought in driver's name. But later on, when the property is sold to innocent purchaser, that fellow should not be in trouble. The driver shouldn't turn around and say, or the owner should not turn around and say, he's a driver, he has never no right to the property, he couldn't have sold it to Ravi. Section 41, therefore, loosely speaking, takes care of bona fide purchaser from Benamidar. His interests are not affected. Whatever between the transaction between the Benami holder and true owner, transferring from the Benamidar, he will not be affected, provided it is a bona fide purchase without notice of Benami. That's what the proviso says. That's what section 41 is. Correct, sir? 53, on the other hand, if you transfer immovable property so that you can defeat the rights of your creditors, that transfer will be void. So you wanted to avoid payment to the bank and therefore transfer it. Fraudulent transfer we call. Fraudulent transfer defeat the creditor. 53 bars it. Here again, the transfer in good faith is not affected. Okay. Sir, I want to ask a small question. Okay. You go to a shop and pay him and purchase a samosa. Kachori है बॉम्बे में, गुजरात में. Command. Okay. Okay. Justice M.R. Shah ने बोला मेरे को, when we were discussing like this, I told him, sir, whenever I give an example, Justice Bharucha used to tell me, Sridharan, why are you giving an example of idli or dosa only, he used to say. Then I also told him, my lord, your lordship always gives an example of sandwich. Justice Bharucha used to give a sandwich. Sales tax mein, when you buy a sandwich in a shop for 50 rupees, the inherent value of the bread is only 2 rupees. Whether you have to pay sales tax on 2 rupees or 50 rupees. I used to give an example of idli, Justice Bharucha used to give an example of sandwich. The service also is part of the value of the goods for sales tax purposes in a restaurant. That's it. Then he told me, my lord Justice M.R. Shah told me, I'm told, he said in Rajkot, in a thali you had some 50 dishes also, he said. And nowhere else in the country, anywhere in Gujarat, the thali culture, you will give you unlimited food. I also asked him, free mein dete to nahi hai? Oh, nahi hoga karke. So you go to a shop, you pay him 100 rupees and purchase a samosa for 10 rupees. He ought to return you 90 rupees only. Okay. That shopkeeper by mistake thought that you pay 500 rupees to him. You returned back 490 rupees to you. Okay. 490 rupees वापस दे दिया. Okay. So you must be thinking how lucky I am. Okay. So it is this mistake. The law then says There is a constructive trust created in favor of the shopkeeper for the excess 400 rupees. Purely it was his mistake, shopkeeper mistake. He never intended to gift you. It is not some volume discount, what is cashback scheme nahi hai. It is not a cashback scheme. So it is called a constructive trust. That principle is used in law to take care of some person, middleman, makes a secret profit. Some politician makes a secret profit when government of India buys some defense equipment. He will say, there is no contract, sir. Why should I got this money? The seller paid me money. How is the purchase concerned? If you want to put me to jail, it's a different matter. Court says, no. You made commission from the seller. I will not go to seller. You hold it in trust for the purchaser. It's a constructive trust. So, three types of trust: express trust or resulting trust. Resulting trust, express trust or implied trust. Implied trust are two types: resulting trust and constructive trust. Okay, very simple principle. I'm just telling you just to get the concept clear. Express trust, the husband transfers the property to a trust for the benefit of wife and children. Okay, that's the case of an express. You will drop a trust deed, go to a lawyer, draw a trust deed, and transfer the property. Okay, that's a trust. There is no Benami, there is no gift in that. Okay, resulting trust. Suppose both of you jointly contribute to a property. A and B jointly contribute to the property. Okay, but is registered in the name of A. Then your respective pro rata ownership is there. That's the resulting trust. And constructive trust is the example of secret commissions or this thing. I saw a book on banking law. The bank, instead of crediting 10,000 rupees to Ravi's account, credits to me. Okay, by mistake. Okay. So I never went back to the bank. मेरे को 10,000 रुपया गलती से credit हो गया, आप ले लो वापस. नहीं. Okay. He didn't say do that. Then since it is credited, I withdrew the money. Tomorrow, later the bank realized, debited my account and credited to Ravi, and bank charged me interest. I was thinking, I can tell the bank, it is your mistake. It is your mistake. How can you charge interest to me? Then the English judgment say, no doubt it's the bank's mistake, but you knew it is not your money. And you used it. Therefore, please pay interest. This is the concept of constructive trust. शाह साहब ने एमआर शाह साहब ने मेरे को जोक बताया था. हाँ बताओ ना, वो टेलीफोन ऑपरेटर का. दो दोस्त बात करते थे. Two friends were talking to each other. A and B were talking to each other, and they're talking nicely. A and B were two friends. They were talking to each other nicely through telephone operator. बीच में टेलीफोन ऑपरेटर था. उन्होंने कॉल लगाया तो बात कर रहे थे. फिर ए ने पूछा बी से, भैया ये सब ठीक है, आप हमने आपको 10,000 रुपया दिया, आप कब वापस कर रहे हो? मोमेंट ए आस्क्ड फॉर द 10,000 रुपीज, बी सर हेलो 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 हेलो, आवाज नहीं आ रही, आवाज नहीं आ रही, आवाज नहीं आ रही है करके. ओके, तो टेलीफोन ऑपरेटर सोचा आई विल हेल्प देम. भाई मिस्टर बी, ए इज सेइंग, ए ने आपको 10,000 रुपया दिया, आप कब वापस दे रहे हो? बी ने बोले मेरे को तो सुनाई नहीं दे रहा. टेलीफोन ऑपरेटर बोले मेरे को सुनाई दे रहा. ऐसा तो आप ही दे देना वापस. ये कोर्ट में बताया था. जस्ट हमारे why I am saying is the bank might have wrongly credited to you. It's a mistake. I used to say, how can I pay? I am liable for interest for bank's mistake. But in you, the money is not yours, you withdrew it. That's where the concept of trust comes. Why I am emphasizing is, I read in some book, many legal principles which cannot be explained by contract law or trust law or something, contract law or tort or property law can be explained by trust law. Some relationships which cannot be adequately fitted with the contract. In the shopkeeper example, when he gave 490 rupees, you say, sir, there is a contract of sale of samosa for 10 rupees only. Okay. There is no other contract. So trust law comes in and creates this 490. Okay. So therefore it is. Okay. I gave this example. Shopkeeper gives a change of 90 instead of 40, customer is holding 50 rupees in trust, constructive trust, secret commission. Acquisition of property through fraud. Okay. The word constructive trust as such is not used in the Act, in the Indian Trust Act. Obligation is the nature of trust. One, it is trust. If express trust is there, trustee is obliged to do certain things. In all other situations of resulting trust, the law calls the word, uses the word Obligated in the nature of trust. It is not actually a trust, obligated in the nature of. Why? You know, criminal breach of trust, हमने सुनते हैं ना sir. Cheating is there, criminal breach of trust is there. That's a very powerful term. So, therefore, this all 81, 82, 94, don't get confused by the jargon, resulting trust, constructive trust, implied trust, express trust, etc. and obligated in the nature of trust. Okay. Right. आगे जाएंगे. Okay, just one more, just finish this 1 minute. Even, this slide 16. Even prior to our Benami law of 1988 and 2016, provisions relating to Benami were scattered and somewhat primitive. For example, in one old, all these are mentioned in Law Commission, मैंने नहीं पढ़ा, ये Law Commission report है, सब एक साथ इकट्ठा किया गया. So I have not done lots of this. Don't think, sir, I spent years preparing for the lecture. Ready material is there available in Law Commission report and everything is gathered there. Okay. So one old Bengal Act says, if arrears of land revenue, property is sold and Benamidar purchases it, Benamidar generally purchases low price. Okay. The government will disown the sale and re-auction the property. So Benami was prohibited. Benami purchases were prohibited under the Bengal Land Revenue Code. Similarly, Section 66 of CPC barred suit in some situations. Okay. This is important. Old 281 of the Income Tax Act says, if you are buying shares as a Benami, you must intimate to the Income Tax Department. What fond hope कौन करेगा? 281 में लिखा भी था that if you buy this thing, you will give intimation and letter to the Income Tax Department. ये पता नहीं किसको बेवकूफ बनाने के लिए law बना रहे. Nobody is going to ever act on it, but that was there. Okay. And then 115 and 41 of the transfer of property and 115 of the Evidence Act is an estoppel. Ostensible owner is barred from avoiding transaction on the ground that is not a owner. What is the meaning of this? The driver having sold to Ravi and taken money from Ravi, later on you shouldn't say, I should not say, I am the owner. Okay. My driver has sold to Ravi. Okay. Then after getting the money, okay, I then go to the court and say, driver has no business to sell, it is not his property. So the true owner cannot go to the court and say, my Benamidar has effected a transaction, you have no right to do that. Poor fellow, you fight with two of you, why are you troubling Ravi in that? So 41, to protect a bona fide transferee, 41 is enacted. These are the scattered provisions of this. Okay. Okay. Need for Benami law. Okay. Sir, these slides are for the audience, for the association. Okay, no problem. This and next 2 pages, a small date chart of all the changes. Okay. In income tax, we don't prepare date chart of facts. फलाना return file किया गया वो तो बहुत कुछ नहीं है. Date chart is necessary for all the amendments because thousands of amendments take place in income tax. Now in GST also. So I always ask for date chart of legislative changes in all income tax matters. We don't do it in excise and customs because law remains practically the same. Similarly in Benami, this slide and next slide is a small date chart. Okay. And whenever you want to look up, if you trace the date chart, you will get an answer. 1972, that fond hope 281 year was introduced, saying you will give intimation to the income tax department. Okay. August 72, there is a report of Justice Gajendra Gadkar, retired Chief Justice of the Supreme Court, Long Commission report of August 72, on what is Benami, etc. Beautiful report. It tells you everything. Whatever I told about trust law, civil law, everything is there in that. So, 57th report, August 1972, of Justice Gajendra Gadkar. Then, very important, sir, I forgot to mention, this knowledge of Benami, etc. will be useful to you when you deal with the Black Money Act also. Beneficial owner is used in Black Money Act also. It will be useful in that also. Okay. So, in 1974, there was an amendment introduced in the Companies Act which says, whenever a shareholder is Benami, true owner's name also should be registered. Why I am referring to this is, this language in 1974 is identical to the language used in Black Money Act. Okay. And people are thinking that
whenever you open a foreign bank account in a company's name and director signs, director becomes the owner of the property. Because they say the beneficial owner is this. I repeat, suppose a private company opened a bank account in Singapore in the name of the and in the bank form, beneficial owner is mentioned as directors. The income tax department says director is a beneficial owner and therefore I'll make him liable to income tax and tax under the Black Money Act. Company they cannot assess because company is a non-resident and Black Money Act does not apply to non-resident. They call the director a beneficial owner and levy tax on him under the Black Money Act. The director may be a beneficial owner according to Singapore banking laws, but is not a beneficial owner under the Black Money Act or any law known in India. That's the reason why. And the best answer for that is given by the February 1974 amendment to the Companies Act. It specifically mentions that where shares are purchased, Benami, the true owner should get his name also added. And it says who provides consideration to the true owner. Okay. So the language of beneficial owner in Black Money Act is identical to what is used in February 74. Okay. Then 1988, sir, ordinance came, Black Money Act. Okay. Benami Act, ordinance came in 1988. Okay. Then August 1988, look at this irony, the matter was again referred to the Law Commission. Okay. 1972, गजेंद्र गडकरी साहब ने रिपोर्ट दिया डिटेल में, 16 साल ने कुछ नहीं किया. Suddenly ordinance was put in May 1988 and matter was referred to Justice D.A. Desai in the Law Commission. Justice D.A. Desai said, sir, you are sitting on it for 16 years, you have suddenly made an ordinance and you want us to give a report in 1 month. Law Commission is meant for doing deep research and coming out with reports after 2-3 years of research. Okay. We are not fast-paced under secretary to the Ministry of Law who will make a bill in the act and get passed into an act. But anyway, since you have asked, we give you a hurried report. Okay. And Justice D.A. Desai was a brilliant judge, but known for strong leftist views. Okay. And his report said, likha bhi hai report mein, he says, all this, act should be strengthened. Gajendra Gadkari sahab ne bola, there should be no criminal liability in Benami. D.A. Desai sahab ne bola, there should be criminal liability. So 1988 Act when it came, based on just D.A. Desai's recommendation, it became criminal offence also. That's where the problem started. Why I am referring to this? Okay. Then 2011, 1988 ke baad 2011, I give a small, so I was telling this example Ravi about one, had an old customs case. Indian importer wrote to his collaborator abroad, आपने मशीन जो भेजा है गलत निकला, defective, please replace it. Okay. That mail sent by the importer to the exporter in 1990, demanding that the exporter replaces the machine. Okay. Then in 2010, there is another mail from the importer thanking the exporter for replacing the machine. Okay. In customs, if the machine is replaced, it will attract custom duty. If the machine is repaired, there is no custom duty. So 1990 May, there is a mail from the importer asking the exporter to replace the machine. In 2010, there is another mail from the importer to the exporter thanking the exporter for replacing the machine. And customs said, in customs, replacement is taxable, repair is not taxable. उसके ऊपर डिमांड लगाई. मैंने क्लाइंट से पूछा क्या किया? तो सही है सर, 1990 मेल तो लिखा मैंने, 210 पे लिखा, हाँ लिखा. तो why you are not paid custom duty when is replacement? Sir, between 1990 and 2010, the supplier repaired the machine twice and sent it to me twice. When both the repairs failed, I told him, अभी नहीं चलेगा, नया मशीन दो. So 2010 में तीसरा मशीन आया, वो नया है. So 1990 का पकड़ा, 2010 का पकड़ा, बीच का छोड़ दिया डिपार्टमेंट ने. Similarly, 1988 का ऑर्डिनेंस था. Okay. Act was two-line act. Na sir, na pair, na tail, nothing was there. Most skeleton act was a 1988 act. 1988 itself is, they woke up after 1972 report of Gajendra Gadkari sahab. Okay, 16 years later. And another 20 years later, they suddenly woke up and introduced an amendment in the 2011. And the bill was not passed because Assembly, Lok Sabha got dissolved, etc. And then 2016 Act came. Why I am referring to this is 2011 bill was there. There's a report of the committee in 2012 and then it became 2016 Act. So 72, then 88 Ordinance, DA Desai report, 1988 Act, Skeleton Act, draconian with no machinery, no details, etc. 2011 bill which was not enacted, in 2012 report, contemplated 2016 Act. This is the background. Okay. That's all in this. Is there
Go to 1988 Act,
Now we can go to 88 Act.
26.
Okay. Why I gave this background is, you all know the judgment of the Supreme Court Ganpati Dealcom, we will be dealing with it little shortly. There, for a transaction which took place in 2011, they wanted to confiscate the property based on 2016 Act. Supreme Court struck it down. So we will deal with it in detail in 5 minutes. Okay. Can I briefly explain the 1988 Act? My apologies, little technical. Therefore, this 88 Act and 2016 Act, 3-4 sections only. Okay. Just bear with me for the next 15-20 minutes. Sorry. Okay. You should have given like indoor pitch, 2 दिन में खत्म हो जाता है match. Instead you go 1 hour. You want to say something, Ravi?
No.
हाँ बोलो ना.
No, no, sir.
Okay. There are only 3 sections in the 88 Act, sir. Okay. And that's the advantage as also the problem of the Act. The definition of Benami is, kindly memorize this. Any transaction in which property is transferred to one person for consideration paid or provided by another person. Tripartite, A transfers to B, consideration is provided by C. A transfers to B, consideration provided by C. That is what definition of Benami is. Please don't mix up with beneficial owner in Black Money Act. That is slightly different. Then 3(1) said, nobody shall enter into Benami transaction. That is prohibition of Benami transaction. Okay. So first there is a definition of Benami in 2A and section 3 says nobody should enter into Benami transaction. Okay. If you do so, what will happen? 3(3) says you will sent to jail for 3 years. 3(3). Whosoever into Benami transaction will be punishable with imprisonment. Whether seller or purchaser or both, all the 3 parties is unclear. Whosoever enters into Benami transaction will be liable for punishment. So these are only 3 sections, 2A, 3(1), 3(3). Section 4 is important. It broadly said, true owner cannot file a suit against the paper owner. The owner of the property cannot file a suit against the driver saying, driver is only a Benami, I am the true owner. So 4(1) barred civil suits by true owner against the driver saying the driver is holding Benami, property belongs to me. 4(1) barred it. Why? Because they felt Benami law was reasonable in 1870s and 1880s when the state was not able to offer protection to its citizens against dacoity, etc. We are talking about this part of the country. We are not talking about some part of the country where dacoity is common even today. Okay. 2A says, this is the definition of Benami. 3(1) says, Benami is prohibited. 3(3) says, if you breach 3(1), we will send you to jail. 4(1) said, if the true owner goes to the court and says property belongs to me, not to my driver, that suit will not be entertained. That is 4(1). Then 5(1) very important. Such Benami property is liable for acquisition by the government. That's what 5.1 says. Okay. And then section 7 said 81, 82 and 90 for a trust act are deleted. Itna hi 4 section tha. Definition of Benami in 2A. 3.1 nobody should do a Benami transaction. 3.3 if you do that we will send you to jail. 4.1 says true owner cannot file a suit against his driver claiming that I am the owner, he is not the owner, though paper is in his name. Then 5 says all Benami properties will be acquired. And section 7 said trust sections are deleted. That's all. Ultimately, just this is important. Prior to 2016 also, this case came before the Supreme Court in Rajagopal Reddy. It said, if a suit has already been filed prior to 1988, kindly note this, if a suit has been filed prior to 1988, that suit will not be governed by the 88 Act. That suit will not be dismissed relying on section 4.1. That's what Rajagopal Reddy confirmed. Mithilesh Kumari said even existing suits will be dismissed based on 1988 Act. That was overruled by Rajagopal Reddy and said that section is not retrospective in the sense pending suits will not be affected. If you file fresh suit post 88, that will be governed by the 88 Act. That's all in this. Sir, you will read the slides for me, this 94. Just read it. Very interesting. Fathers are always Pyarelal.
Pawan Gupta's son purchased property. Property registered in name of Pawan Gupta. Pawan Gupta gave it on rent. Pawan Gupta moved for eviction against tenant. Tenant claimed transaction Benami as consideration was provided by father.
देखो कितना very noble tenant. जब तक he is a tenant, he has no problem. Moment landlord says please vacate, the first thing tenant says is Mr. Landlord, you are not my owner. हम लोग there's a judge in Delhi High Court. So first thing a person forgets is English whenever DT enter a coffee posa करके. Otherwise he will know because in coffee posa you ought to be given the document, the language is the detainee understands. So he says, I know only Hindi. Okay. So the judge says, a person who knows English very well, suddenly when DT enter coffee posa, he forgets English. Okay. Oh, the department is, sir, on English mein sign kiya. So signature people can sign English, may not know English. And sometimes people ask for translation of Maithili language, some remote languages. If it is not given, similarly, whenever a landlord wants to move against the tenant, the first defense the tenant takes is, Mr. Landlord, you are not my landlord. You don't have a valid title. That's the stand he took here. He told the transaction with Pyarelal and Pawan Gupta is Benami. Why? Because Pyarelal father provided consideration. And you'll see the definition next page. Benami is defined as consideration paid or provided by somebody else. Consideration paid or provided. Okay. So you and I accountants understand provision is different from paid. Paid is actually paid, provided to be paid. Okay. But the tenant argued, father has given the consideration, he has provided the consideration, therefore transaction is Benami. I repeat, the tenant's argument was, father has provided consideration, definition of Benami is consideration paid or provided by somebody else. Okay. Since father has provided consideration, it is Benami. Supreme Court said, Bhaiya, oh, that's not the meaning of consideration paid or provided. Consideration paid is considered immediately paid or agreed to be paid. That is what the meaning of provision of consideration. It is not talking about source of the money. That's what Justice 94 judgment says. So that's important. Keep that in mind. Okay. Because these are the points department uses in proceedings. You have provided the consideration. Provided is not referring to the source. Providing it deferred consideration. Immediate consideration, deferred consideration. That's what it means. Okay. All right. Yeah, now kindly come to this 29A. Sir, now, ultimately, after hearing all the stories of Rama and Mahabharata, now I am coming to the current act of 2016. Okay. Why? One judge, I don't know, you people recollect, Honorable Prime Minister Mr. Rajiv Gandhi was a youngster, dashing. He says, I don't want to waste my time in learning history. I am looking at the future. करके उन्होंने बोला था. A professor of history replied back, those who forget history become part of history. करके. So for a lawyer, historical background, evolution of law, legislative history is a very important tool. Okay. So you simply look at the current section, you are bound to make mistakes. If you know the background, you can have complete picture. That's the reason why I gave this. Okay. The modern trend is, look at India Qanun, Google, look at the latest case. Nowadays what? Matter is being argued in the court, discussion taking place with the lawyer and the judge in the court, that also gets reported as if some newspaper report. All that is irrelevant. Ultimate judgment of the court alone is, अभी स्लो बनेगा का double taxation MFN clause का चल रहा है, as is some live commentary. जज साहब ओरली क्या पूछते हैं, वकील साहब क्या जवाब देते हैं, उस वो रिपोर्ट होता है. मेरे को कोई झूठ नहीं बता सा ये हुआ, ऐसे ये रद्दी साइड में रख दो, लेट द जजमेंट कम. जजमेंट के बाद भी इंटरप्रिटेशन ऑफ जजमेंट इज डिफरेंट मैटर. दिस इज डिफरेंट फ्रॉम द लेजिस्लेटिव हिस्ट्री. ओके. नाउ द न्यू डेफिनेशन इज where a property is transferred or held by a person and the consideration has been provided or paid by another person. So first thing sir, consideration provided or paid, वो आपको बता दिया था मैंने. Deferred consideration is what consideration provided, not source of a source of a source. वो तो ठीक है. So new word now is held करके लिखा सर. Is it not so? Old definition says property is transferred or is held. What is the meaning of this held? Somebody is saying you continue to hold the property, it becomes Benami. That is not the meaning. What is the meaning, sir?
When the property is created for the first time, and then it comes into the possession of the transfer.
Please explain in languages people can follow. Don't be like me.
When the shares are issued by the company, either in an initial public offering or etc., that's when the property is held by the person. When there is an existing property and that is transferred, that does not amount the property is held by the transferee.
So the old law says property is transferred. So property is transferred, natural applies to pre-existing property. In case of shares, the judgment said that, no, what is that, Can Bank or Code Distilleries etc. says, when a company issues a shares, property is created the first time, there is no transfer of a property. Okay. So transfer of a property held Benami under the pre-260 law dealt with existing property transferred and held in wrong name. But issue of shares creates the property the first time. There is no transfer of the property. To take care of Benami purchases of shares in the Benami name, amendment is introduced, is held by. That's the reason I want to tell you. Is held by is used as opposed to transferred for. Up now 54E or F, whatever is there. Property purchased or acquired.
56(2)10.
No, capital gain deduction for house property. Within 2 years purchases or 3 years constructs.
54F.
54F. That's the same thing. You purchase means existing property is purchased or you construct. The word purchase will not be used good enough for construction. Similarly, the property is transferred or held by. क्या गलत बोला sir? Analogy is wrong. Correct, no? That is the only reason. It happened also. In Can Bank financial case, department invoked the old post-88 Benami law against Can Bank for this. Then Justice Sinha said, Bhaiya, this is issue of shares. Okay. Issue of shares, there is no transfer of property. Therefore, it will not be Benami. So next time when the amendment was brought, they took care of, to take care of that transaction. So the reason why I am referring and troubling you on 2A is, my apologies, I repeat, provided or paid. Provided is for deferred consideration. I get confused by this number of times. Therefore, I am troubling you to get this point clearly in our mind. Transferred or held is for this reason. Some people are saying continued holding of property. So it was not Benami pre-2016, it is Benami post-2016 because he continued to hold it. I will invoke the act for you. So we used to argue, sir, it was not Benami earlier. No problem. It is now Benami under the new definition. You continue to hold the property, therefore I will apply the 2016 act. This is the reason why I am harassing you. Please get the correct meaning of the word held. Not for driving vicarious pleasure. Okay. वो भी मजा आता है, लोगों को तंग करना भी अच्छा है. But the real reason why I say held is to distinguish between transfer of pre-existing property and property created by the transaction. That's the only reason. And this is a live example because department having failed in Ganpati deal comms case says in future, if you continue to hold the Benami property, which was not Benami pre-2016, we will invoke this section. They are saying that. We have to say he is held by is not for this purpose. That's the reason I am telling you. Okay. Right. And now kindly see the definition B. The property is held for immediate or future benefit of the person who provided the consideration. Owner buying in driver's name and owner continuing to stay there. Or rent from that goes to the owner. If on the other hand, if you can prove that for its reward for loyal services which the driver has rendered to you, and therefore after purchasing the property he is staying in that property with his family, then it is not Benami, it is in the nature of a gift, okay, and not in the nature of trust also. So both the conditions have to be fulfilled simultaneously. Earlier section says transaction, now section says transaction or arrangement. That's new. And sometimes this Ravi wants to trouble me. Slide me like this. What is the difference between transaction and arrangement? मेरे को transaction का meaning नहीं मालूम था, अभी arrangement का क्या meaning मालूम होगा? Okay. I am told this word arrangement is used in guard provisions. Any structured thing with a predetermined end in mind. Seminar में बहुत अच्छा arrangement किया करके. What do you mean by that? In a systematic, organized manner with a particular end result. That's the meaning of the word arrangement. Okay. So in other words, even if ultimate aim should be arrive at this particular result, that's what an arrangement is. Okay. Then sir, mercifully, section has few exemptions. Some of them are unnecessary, even without it you will get the benefit. Property held by HUF for the member of benefit of member of HUF. It never Benami ever. Okay. HUF may because you have jointed several interests acquired at time of birth, etc., in Mitakshari law, etc. Okay. So sometimes the so-called over-thoroughness of the law ministry, they put some exemptions which are unnecessary. Okay. That's the first one. Then person standing in fiduciary capacity like a trustee, partner, director. Naturally, they are never a Benami, but section makes it clear that it will not be this thing because the director will buy in the name of the company and sign the document. That doesn't make it Benami. Okay. Then my father-in-law's example I told you. Old man is no more, but he asked me this question before he passed away. 3 is for that. Any person being an individual, if you buy in the name of his spouse or name of child, and consideration is provided by him from known sources of income. That's important. So you can buy in your wife or child's name, no problem, but it should be from your accounted income. Then it will not be as Benami. Okay. 4. Similar to 56(2)(10), brother, sister, lineal descendant, and consideration of known sources of income. These are exclusion from the definition of Benami. Okay. HUF, fiduciary capacity, spouse, and then children and lineal descendant, ascendant. Okay. Okay. This capital B, capital C, capital D are new. Our chairman Saab met me before the session and he was saying, सर बैंक अकाउंट ओपन कर ले, उसका भी बेनामी कर रहे एक्ट में. ओके. My humble submission is, they want to use a sledgehammer to kill a fly. What normal assessing officer could have assessed under section 68, for that also they want to invoke Benami now. Okay. Because in Benami, property is lost, penalty is put, and prosecution is also there. I was joking, the first set of persons against whom the Benami Act should be introduced may be some of the officers of the department, because you give such wide powers. It's always misused. Okay. Now, B, C and D are important, and these are not ever part of a normal meaning of the word Benami. While existing definition always dealt with tri-party, B, C and D is bi-party. Correct, no Ravi? Yes. कुछ आपको बोलना है तो बोलो. Don't hesitate. I have already told them, I am the Benami. Now they think that I am the real owner and you are the Benamidar. So, rebuttable presumption. Burden of proof is fluctuating, bolte na sir. Burden of proof is not static. As and when you keep proving, the burden shifts to the other party. So, if I prove or disprove, then burden shifts to you.
I will take the example of that civil case law which you are.
Which is it? What did that say, civil case law say?
I don't want to make
Open your mouth. आवाज नहीं हो रहा है. उसका भी हमारे पास तरीका है. Whenever I don't have an answer, suddenly I will ask you. उसका जवाब दे दो करके. Okay. Okay. Let us just spend few minutes. जिगर भाई, बहुत बोर हो गए. और बाकी है थोड़ा. पहले आपको बता दिया transaction arrangement is a new word. In the old act, the word transaction is used. Now transaction arrangement both are added. Okay. Some difference is there, but keep this in mind. Carried out or made in a fictitious name. You get the, I was giving an example of the owner getting the property registered in his Mali's name or cook's name, etc. as an example. Okay. But here this fellow is even further. He gets it in the name of a non-existent person. So, I was told by my close friend of mine is there, and he's a practitioner in income tax, a very good lawyer, Jitendra Jain. Okay. Income tax notice area. You purchased this property in Dadar for some 15 crores करके 10 साल पहले. आपका पैन नंबर भी है, आपने बोला भैया प्रॉपर्टी मेरा नहीं है, कुछ भी नहीं है. Somebody has used his PAN number and purchased in his name. This was in 2001 or 2. Okay. हम लोग GST में बोलते हैं ना हवाला ट्रांसैक्शन वगैरह. यूके भी होता है वो. Only difference is they called hijacked VAT number. Everything is the same. Only dignified term, hijacked VAT number. So Ravi Samna VAT registration number is 200. Okay. My VAT registration number is 50. I don't raise invoice in registration number 50, I raise in 200. Okay. I take somebody else's VAT name, sell, take the money, and the GST department comes, by VAT number to uske paas jao karke. Okay. That is not fictitious name. Okay. Fictitious means non-existent. Okay. I am told PANs have been issued in non-existent names. पहले तो होता था बहुत. इसलिए तो आधार आ रहे हैं. So Aadhaar also is using fictitious name, then they will use something else. No, I don't know, it doesn't happen nowadays. In Jaipur airport, in the olden days, आपका security वाला in the security lounge screen you. 50 meters later, near the record will be again screened. I said, "Bhai, kya hai?" Sir, security alert hai, therefore double checking. I said, you keep 10,000 checkings also. If you don't do it once thoroughly, you can say, you do once thoroughly is enough. Similarly, if your PAN number database is accurate, no problem. Fictitious PANs are there. If you introduce Aadhaar, fictitious Aadhaar also will be there. That can never be solved. B is a transaction arrangement entered into in a fictitious name. Okay. And this is bi-party, not tri-party. And this is not ordinary meaning of the word Benami. where the owner of the property is not aware or denies knowledge of ownership. अपने जितेंद्र सिंह का नाम पर जो बोला जितेंद्र जैन, that was genuine. Poor fellow has nothing to do. He was छोड़ दिया उसको. Then they realized there's a mafia in Bombay operating in this. I don't know about Ahmedabad. In the port area, there's a mafia. Imported goods land. Goods are not clear for 2-3 days, let us say. The mafia will put it up for auction. You will never get the property. They will negotiate with you. अपना property आप उनसे खरीदो. Okay. Double taxation. Once to the supplier and to the mafia. This is this. He is not aware of the ownership or denies knowledge of the ownership. Person providing consideration is fictitious. Various shades of it. These are entirely fictitious transactions, not Benami in the classical sense. Next page. I am not too clear of what I have written myself. Okay. A sham transaction, the judgment of Lord Diplock in 1960. Both of you write into a contract that I will engage Ravi Savna for giving this lecture. Okay. You write a written contract. Okay. When somebody else calls him, say, today you come for a meeting, he will say, sir, I have an engagement with this. Actually, he wants to attend a wedding that day. So you want to tell the client, I have a seminar. So you write a document, never intended to act upon it. Sham transaction is, there is a contract between the parties, which parties never intend to act upon. They write a contract. Sir, I agreed to sell this property to you. Both of us know I am not going to sell, nor he is going to buy. That's a sham transaction. How do you justify that? The answer is, kindly listen a little carefully to me. You may say, it, क्या joke बता रहे हो आप? Contract can be in oral or writing, sir. Oral contract भी हो सकता है ना, sir? हर्ष भाई? Contract oral भी हो सकता है, writing भी हो सकता है. First written contract between Ravi and me is, I will sell the property to you, you will buy. Then oral contract is, I neither will sell nor will buy. Okay. So, parties simultaneously enter into two transactions, one a written contract, another oral contract. Oral contract annulling the written contract. Okay. Court said, if you can prove the oral contract, then we will not act on this written contract. So that's a sham transaction. Sham transaction is a transaction which is never intended to be put through. And kindly note, this sham transaction is a very pet point of the income tax department. ये तो sham है, sham है करके. Sham transaction can be called a sham only by the parties to the document, not by a third party. Okay. I and Ravi genuinely want to enter into transaction. Income tax department cannot say it is sham. Between two of us, we can call it sham. So, sham transaction means a transaction never intended to be put through. That is one. And two, it is the party to the contract to say so, not third party. Because the pet topic of income tax department is sham. That's not the meaning of sham. Okay. Benami transaction actually exists, but in wrong name, etc. Okay. So that's the difference between the two. Okay. Why I am saying this is, if you go to a criminal lawyer, if the prosecutor wants you to book you for criminal breach of trust, that fellow will say it's a cheating case. He will not say there is no offense. His whole aim would be to reduce the gravity of the offense. Okay. Why I am saying, if it is a sham transaction, you may have some problem somewhere else, but it will be out of Benami Act. Kindly note this. Why I am saying is, just as a criminal lawyer wants to defend you from criminal breach of trust by saying it's a case of cheating. Okay. Similarly, sham transaction may have some other problem, but it will be out of the draconian Benami Act. Okay. It may not work in practice, but just keep this harmony in your weaponry. Okay. Right. We have 10 minutes only. Can you go back to case study 2? You can back and explain this, please.
So, as we discussed earlier, that the word is held by in 2(9) clause A only deals with the case of new issuance of shares. So the property which is not in existence earlier. The property which is in existence earlier and is transferred would be governed by the word transferred. But if there is a case of fresh issuance of shares, then it will be governed by the word is held by, which was introduced for the first time in 2016. It was not there in 1988. The,
हाँ बता दो explain करो can bank finance जो
that's right.
ठीक है and this word held is judgment of Supreme Court in can bank finance and to overcome that this amendment is I am repeating held I am using this because department says continue to holding of Benami property post 16 will be governed by that to get over this okay. This is on the retrospective. Here, I want you to explain Ganpati. Rest is not needed, no? May, this bona fide transferee with notice. Consequences. Here they go. Property. Yes. Explain this. Take your time.
So, the definition of Benami properties means any property. Then the Act also defines the word property. Now, if you read the last 3 lines of
read it once.
Property means assets of any kind, whether movable or immovable, tangible or intangible, corporeal or incorporeal, and includes any right or interest or legal documents or instruments evidencing title to or interest in the property, and where the property is capable of conversion into some other form, then the property in the converted form, and also includes the property and also includes the proceeds from the property.
Split it into small portions.
So there are 3 parts to the definition of property. One is assets, movable, immovable, tangible, intangible. The second is property which can be converted into some other form. And third is proceeds from such property.
Second example.
So the example of second would be compulsory convertible preference shares, where the preference shares are converted into equity shares, or compulsory convertible debentures, where debentures are converted into equity. So debenture itself can be Benami property, and if those debentures are converted into equity shares, then those equity shares will also be Benami property, because the debenture is capable of conversion into some other form, that is equity shares. An example of third, proceeds from such property, if you sell the equity shares, then the sale consideration itself.
Very draconian. Last part is most draconian. Proceeds from the property. Will it refer to that very proceed or any equivalent sum? So we say sale proceeds is smuggled property. So if I sell smuggled gold and keep that 100 rupees in a locker, that alone is smuggled proceeds, any 100 rupees with me. Okay. So here it doesn't refer to the consideration of the proceeds of the property. Okay. It can be read as equivalent sum also. Okay. On the first part, I want you to note, property is not referring to the physical thing. It can include leasehold rights, mortgage rights, etc. Okay. So that's the last line. Leasehold rights, mortgage rights, they can also be. You can't say property is given on lease, therefore it cannot be Benami property, etc. Okay.
And there may be a case where the cash itself is the Benami property. But if the cash is used to buy some other property, then whether that other property will fall within the second limb, that property in the so converted form. In my view, the answer is no, because it is not a case of property being capable of conversion into some other form.
Okay. Our department is relying on that part to even, okay. Yeah. Now the consequences of Benami, आपको डराने के लिए नहीं बोल रहा हूँ, एक्ट में लिखा है, मैंने नहीं डरा रहा हूँ, एक्ट में जो है वो आपको बता रहा हूँ, okay. Because it's draconian. 3.1 says no person enter Benami transaction. New 3.2 is same as old 3.3. You can send to jail for 3 years. Okay. Then 3.3 says if you do Benami post 2016, you will in addition be liable under chapter 7. And chapter 7 and 6 etc. provide for confiscation of the property, putting fiscal penalty also apart from prosecution. Okay. Then 53.1 is a new draconian provision. If the transaction is entered into the object of defeating any provision of law, avoid payment of statutory dues, avoid payment to creditors, then they can be sentenced for 1 year up to 7 years. Okay. Then, explain this 27. Notice. So now, adjudication proceedings under the Benami Act. I am not telling about the procedure. Show cause should be there, this thing, etc., etc. What happens to bona fide purchaser of Benami property? After you pay the consideration, if it is held to Benami, then they can take away your this thing. For example, in land deals, you buy and sell, but if the property is already under notification of the Land Acquisition Act, gaya kaam ka aapka. Government will take it away from you. You may go and fight with the seller. Similarly, in a Benami property, if you purchase a Benami property, you might be unaware of it being Benami. What are the consequences? Just listen to Ravi first. This thing. Just explain that prior to notice and post notice.
So, whenever there is a Benami property, first you will receive a show cause under section 24, subsection 1. Thereafter, after giving you opportunity of being heard, etc., it will pass an order provisionally attaching the property. Then the matter will go to the adjudicating authority. Whether adjudicating authority finally approves the attachment or not. If the adjudicating authority says that it is not a Benami property, then the provisional attachment fails and it is not a Benami transaction. If the adjudicating authority says that yes, it is a Benami transaction, then the authority will pass an order under 26(3), and then the property will vest into the central government. It will not vest into the Benamidar or into the real owner.
Okay. Yeah, 27 to read.
27 deals with confiscation and vesting of Benami property, which we just explained.
Acquisition of bona fide purchase prior to notice, he is protected.
Yeah. So subsection 2 says that
Very important. Bona fide purchaser, what is the effect? 27, read it.
nothing in subsection 1 shall apply to property held or acquired by a person from the Benamidar for adequate consideration prior to the issue of notice under 24(1) without his knowledge of the Benami transaction.
Read again, please read again.
Nothing in subsection 1 shall apply to property held or acquired by a person from the Benamidar for adequate consideration prior to the issue of notice under subsection 1 of section 24 without his having knowledge of the Benami transaction.
So if a bona fide purchaser has purchased the property not knowing it is Benami, he is protected, provided it is prior to issuance of notice. If after the notice has been issued, if he proceeds to buy and is bona fide purchaser, he is not getting the protection. Why I gave you the example land acquisition? After the notification is issued, proposing to acquire, transfer you made is void. Similarly, so this is not to say any bona fide purchaser without notice of Benami is protected. A bona fide purchaser without notice of Benami is protected provided notice has not been issued. If post notice stage, not a final adjudication stage, then also protection will not apply. Okay. Next. छोड़ दो गौतम छोड़ दो. Yes. That's okay, that's all. Now please, will you explain Ganpati deal? Yeah. Yes. I will sit down. Explain this. Ganpati deal, he has read that hundreds of times. Okay. So he will explain fully the landmark judgment of Justice, Chief Justice Ramanna. Okay.
So in case of Ganpati Dealcom, Company A purchased a property in 2011. Then in 2012, B and C purchased 99.99 shareholding in Company A. So Company A effectively became subsidiary of Company B and C. But there were two directors who held directorship in A as well as in B and C. So the department issued a notice in 2017 after the amendments were made in 2016 to the Benami Act. They said that company A is the Benamidar, the real owners are the directors, and the Benami property is the property which was purchased by company A in 2011.
Those facts are not necessary. The transaction question is put through in 2011.
Yes.
Amendment came in 2016, and they want to rely on the amended provisions.
Yes.
For 2011.
Right.
And this is not for sentence, criminal prosecution, etc. They want to acquire the property. And they say acquiring property was brought in 1988 itself. Department's argument was 1988 said we can acquire Benami property. Now 2016 says they can confiscate Benami property. Earlier word used was acquire Benami property. 2016 Act says confiscate. Now they propose to confiscate. And the argument of the department was, we are not concerned with criminal prosecution, etc. Acquisition was brought in 1988 itself. Therefore, it is not retrospective. Is that the controversy?
Yes.
Now, please explain.
So the Supreme Court.
Go a little slowly.
Yeah.
Very important point.
So Supreme Court first examines the 1988 Act, the definition of Benami transaction itself. If you remember in 1988 Section 2, Clause A, the definition of Benami transaction only covered the tripartite arrangement. A paying consideration to B and the property is registered in the name of C. Here it is a case where there are no tripartite, there are only two parties. Company A purchasing property from the seller. So that's the first thing. The Supreme Court says that in the 1988 it was only tripartite arrangement which were covered. If you look at the new act, it covers tripartite as well as bipartite transaction. Secondly, the definition of Benami transaction in the new act also says that it is a tripartite arrangement and the property is held for the immediate or future benefit of the person who is providing the consideration. So there is beneficial interest also covered in the Benami transaction definition. But that was not so in 1988. Then Section 5 did not cover any adequate safeguard with respect to the Benami transaction. Therefore, the real question to answer that whether 2016 amendment is prospective or retrospective, they examined whether the Section 3 and Section 5 of the 1988 are constitutional or unconstitutional. Though that was not the controversy before the Supreme Court. Yet they say that it does not bar us from opining on that aspect. So they first say that Section 3 and Section 5 of the 1988 Act are unconstitutional for these reasons. In criminal provisions, there is always a concept of mens rea. There is a guilty mind. Supreme Court says that was absent in the earlier provision of 3 and 5. Then it says that there was no concept of beneficial ownership, that the property is being held for the benefit of someone else who is providing the consideration. Then the proceedings in Section 5 are against the property. They are not against any person. That is, the proceedings are in rem and not in person. And Section 5 and Section 8 of the old Act says that the necessary procedure will be prescribed, but those were never prescribed. So the Supreme Court says that Section 3 and Section 5 of the 1988 Act are unconstitutional when they were enacted. That is since 1988.
The 88 Act as enacted was too brief to be good. Everything was left to the rules and rules were not framed. It is a case of an extremely skeletal statute. Court generally err in favor of the Parliament and say Act gives broad details, but detail can be governed by the rules. But your Act is too brief. Acquisition will be done in manner to be prescribed. No procedure, authority, nothing was there. So the 1988 Act was struck down, if you may say so loosely, on the ground of being too vague to be an act. Once 88 Act is struck down as unconstitutional, then rest are easy.
So the argument put forth by the Union of India was that 1980 Act we had created an offence, but there was no machinery or procedure to proceed against the Benamidar or the real owner. And that's what we had tried to achieve by 2016 amendment. Then the Supreme Court analyzes 1988 Act and 2016 Act simultaneously and says that there are various gaps left in 1988 which are trying to cover up in 2016 amendment. So they analyze the definition of Benami transaction, they analyze the definition of property, they analyze the concept of mens rea which was put in section 53 of 2016 Act, and then that's when they say that the 2016 Act brings out substantial changes in the Benami Act. And when we have hold that section 3 and section 5 of the old Act are unconstitutional, the new amended provisions can't be explanatory or clarificatory, or these can't be simply a machinery or procedural provisions. These are substantive provisions and therefore they will not apply retrospectively. They will only cover transactions which will take place after 2016. And they will not cover those transactions which has taken place prior to the amendment coming into force. Then the next question was whether the confiscation in section 5, whether it is punitive in nature or not. Because the assessee was relying on Article 20 of the Constitution, that if the provisions are punitive in nature, then you cannot apply them retrospectively. You cannot cover the past transaction, you cannot hold me liable for the past transaction when the law was not in force. So then the argument was that liability under section 5 of the 2000 in the Benami Act is whether it is civil in nature or criminal in nature. The Supreme Court says that yes, it is civil in nature, it is not punitive, but the provisions as amended by 2016 suggest that they can't be made retrospective. Thank you.
So we thank you for the interactive session. With a very brief note, I would like to say, sir, even for a layman like me, it will now become difficult to be trapped under this Benami Act. And for most of us today here, what you said, shed your fears and everything will fall in place, would be the best takeaway. Thank you so much, sir, for being here and enlightening us.
Thank you.
I would now request V. Sridharan, sir, to felicitate the members on the dais with a memento, beginning with Advocate Harish Shah, sir.
Thank you, Ravi. Thank you very much. You can pay thanks.
Followed by Advocate Umesh Majmudar. Advocate Nitin Vadodaria. Advocate Kandat Gajjar. Madhusudan Patel.
Namaskar, sir. Thank you very much. Thank you. Thank you. Namaskar.
And C.A. Siddharth Thakkar.
Namaskar, sir. Thank you very much.
Thank you so much, sir. And here we come to an end of the sixth technical session. And I would now request everyone on the dais to please come forward for a group photograph.
Aram se, sir. Slowly.